I'm Arthur Pendleton, and I've been practicing criminal defense law in Texas for 18 years. Most people come to my office when they're scared, facing consequences that could shatter their lives. But few arrive as utterly broken as Daniel Miller did that scorching July afternoon. He sat across from me, hands trembling, sweat beading on his forehead despite the air conditioning. His eyes, normally bright, were haunted, wide with a terror I knew all too well. "They're saying I stole millions," he choked out, his voice hoarse. "From my own company, from my own life's work." He had been indicted on multiple counts of felony theft and embezzlement, facing up to 30 years in a state penitentiary. The prosecution, spearheaded by a zealous district attorney, wasn't just seeking jail time. They were seeking to dismantle his entire existence, publicly branding him a fraud. What made his case particularly shocking was that Daniel wasn't just an employee. He was a co-founder of Horizon Tech Solutions, a successful software development firm he'd built from the ground up over 15 grueling years. This wasn't some faceless corporation, and this was his legacy, his identity. And now, everything, his future, his family's security, his very freedom, hung precariously in the balance. The potential financial losses alone, aside from the crushing prison sentence, were staggering. Millions in alleged missing funds, civil suits threatened, his reputation in tatters. Here's what you need to understand about the kind of charges Daniel was facing in Texas. Under Texas Penal Code Parv 31. 03, a person commits theft if he unlawfully appropriates property with intent to deprive the owner of property. The unlawful appropriation can include taking property without the owner's consent or obtaining it by deception. When the value of the property stolen is over $300,000, as it was in Daniel's case, it escalates to a first-degree felony, carrying a possible sentence of 5 to 99 years, or even life, in prison, along with substantial fines. Embezzlement, while often used interchangeably with theft in common parlance, technically falls under the broader theft statute in Texas. It specifically refers to the unlawful taking or misappropriation of funds or property entrusted to one's care. In Daniel's situation, the accusation was that as a high-level executive and co-owner, he had betrayed that trust, using his position to divert company funds for personal gain. The district attorney's office needed to prove beyond a reasonable doubt that Daniel acted with the specific intent to deprive Horizon Tech Solutions of its money. This wasn't merely a mistake or an accounting error. It was presented as a deliberate, calculated scheme. The stakes couldn't have been higher, and the path to proving his innocence, given the intricate financial allegations, would be a labyrinth of ledgers, digital footprints, and human deceit. Daniel Miller, 42 years old, wasn't your typical tech CEO. He was quiet, brilliant, with a developer's mind that saw patterns and logic where others saw chaos. He co-founded Horizon Tech Solutions with his college friend, Richard Thorne, 45, who served as the chief financial officer. While Daniel was the visionary, designing their flagship enterprise software, Richard was the numbers man, managing the company's financial operations, investments, and client accounts. For 15 years, their partnership had been solid, built on trust and shared ambition. They'd started in a cramped Austin garage, coding late into the night, living off instant noodles. Now, Horizon Tech was a major player in the enterprise software market, employing over 200 people with offices in 3 cities. Daniel had always handled the technical side, leaving the financial intricacies to Richard. It was only when a major investor started asking uncomfortable questions about quarterly reports and a sudden dip in profits, despite robust sales, that Daniel began looking closer at the books himself. He wasn't trained in finance, but even his layman's eye caught irregularities. Large, unexplained transfers to shell companies, invoices that seemed inflated, and a peculiar pattern of expenditures that didn't align with company projects. When he confronted Richard in May of 2023, his partner grew agitated, dismissive, and then, shockingly, turned the tables. Within weeks, the investor had reported their concerns to federal authorities, and Daniel, the quiet visionary, was suddenly the prime suspect. The accusation painted him as the mastermind behind a sophisticated scheme to embezzle $3, $8 million, a figure that punched a hole through his life savings and threatened to unravel everything he'd ever worked for. When he walked into my office, he looked like a man who'd seen his world end. His wife, Sarah, sat beside him, clutching his arm, her eyes swollen from crying. "I didn't do it, Arthur," he whispered, his voice cracking. "I swear to God, I didn't take a dime." His vulnerability, the sheer injustice of it all, resonated deeply with me. I took the case because I saw a good man, utterly out of his depth in a malicious legal storm, desperately needing someone to fight for his truth. My investigation began the moment Daniel retained me. The first hurdle was the sheer volume of material: bank statements stretching back 5 years, company ledgers, tax returns, internal audit reports, emails, and server logs. The prosecution's case, built largely on Richard Thorne's testimony and the initial audit, made Daniel look incredibly guilty. It showed large sums transferred from Horizon Tech accounts into a series of limited liability companies, some with names suspiciously similar to Daniel's wife's maiden name, and then further into offshore accounts. My strategic thinking process immediately told me that if Daniel didn't do it, someone else did, and they were clever enough to make it look like him. We needed to prove Richard Thorne was the actual culprit. I brought in Dr. Arlene Kincaid, a forensic accountant renowned for untangling complex financial frauds. She had a bulldog's tenacity and an eagle eye for discrepancies. Alongside her, I hired Mark Jensen, a digital forensics expert, to dive deep into Horizon Tech's server infrastructure, personal computers, and any accessible backups. Jensen specialized in uncovering deleted data and metadata. The initial phase was grueling. Days blurred into weeks as Kincaid meticulously combed through millions of transactions, while Jensen painstakingly recovered fragments from Daniel's company laptop and desktop. We hit dead ends. The paper trail, on the surface, seemed to implicate Daniel. Transactions bore what appeared to be his digital signature, authorized from his company IP address. Opposing counsel Eleanor Vance, from the formidable corporate defense firm Vance & Albright, was a known pitbull. She represented Richard Thorne and was already positioning him as the wronged partner, the whistleblower who had uncovered Daniel's deceit. She regularly fed information to the DA's office, tightening the noose around my client. I remember one particularly frustrating afternoon. Kincaid called me, her voice weary. "Arthur, all signs point to Daniel. The routing numbers, the timestamps, the authorization codes. It's all there." My stomach dropped. We had to dig deeper. I instructed Jensen to expand his search, not just focusing on Daniel's machines, but looking for any anomalies across the entire Horizon Tech network, including archived backups and even Richard Thorne's corporate email server. My gut screamed that Richard was hiding something. The biggest obstacles were the sheer cleverness of the scheme and the lack of any obvious physical evidence. There were no bags of cash, no secret Swiss accounts directly in Daniel's name. It was all a sophisticated digital shell game. But I wasn't done. I knew the truth was hidden in the digital ether. We needed a crack in the facade, a single piece of evidence that could unravel the meticulously constructed lie. And then, after nearly 2 months of relentless digging, Jensen called me. His voice was calm, almost unnervingly so, but I could hear the excitement thrumming beneath. "Arthur," he said, "I found something big." The discovery came on a sweltering late September evening. Mark Jensen's voice on the phone was the calm before a storm, but my heart raced when I saw the attached documents he'd sent. He had managed to access a deprecated backup server for Horizon Tech's email system, a relic from an older IT infrastructure that had largely been forgotten. What he unearthed there was nothing short of a smoking gun. He found a series of emails exchanged between Richard Thorne and a third party, dating back over a year. The initial messages were innocuous, discussing a side project, but they quickly escalated. One email, timestamped April 12, 2023, less than a month before Daniel was accused, contained a detailed plan titled Phase 3, Mitigation and Redirection. In it, Thorne explicitly outlined how he intended to reallocate the outstanding $3 $8 million, funneling it through a network of shell companies in the Cayman Islands. But that wasn't even the most devastating part. Jensen had also recovered a series of deleted emails where Thorne discussed creating forged digital signatures for Daniel, modifying metadata on critical financial spreadsheets to make it appear as though Daniel had made the changes, and orchestrating the timing of the discovery of the embezzlement to pin it squarely on my client. He even had specific instructions to a tech consultant on how to plant evidence, a cleverly disguised macro in a spreadsheet that would automatically route funds and then self-delete. The true breakthrough came when Dr. Kincaid, armed with Jensen's digital evidence, cross-referenced Thorne's side project emails with our deep dive into the company's financials. She discovered a hidden, undisclosed bank account in a small offshore bank, directly linked to a shell company named Pinnacle Holdings, LLC. This LLC, contrary to Thorne's claims, was solely controlled by him, not Daniel. The $8 million wasn't simply missing, it had been systematically siphoned off over 2 years into this very account. The digital evidence showed Thorne accessing and manipulating these accounts from his personal workstation, often late at night, long after Daniel had logged off. Jensen's recovered metadata revealed that the digital signatures used to authorize many of the fraudulent transactions attributed to Daniel were actually executed by Thorne's distinct IP address, then digitally masked and backdated. The metadata was the key. It was pristine, unalterable proof of original authorship and modification. I stared at the screen, the weight of the injustice lifting, replaced by a surge of furious determination. This wasn't just evidence, it was irrefutable proof of Thorne's malicious framing. When I called Daniel and told him, there was a long silence on the other end, then a raw, guttural sob. "So, it wasn't me," he choked out. "It wasn't me." He wept openly, tears of relief and anger, pouring out years of fear and despair. That moment, seeing his burden lifted, confirmed why I do this job. This evidence wasn't just legally significant, it was life-altering. The Travis County Courthouse on the day of the trial was a solemn, imposing structure, its limestone facade gleaming under the Texas sun. Inside, the air in Judge Evelyn Reed's courtroom was thick with tension, heavy enough to cut with a knife. Judge Reed, known for her sharp intellect and no-nonsense demeanor, presided from a high bench, her gaze missing nothing. The jury box was filled with a diverse group of 12 Texans, their faces unreadable. The prosecutor, ADA David Martinez, a man known for his dramatic flair, presented his case first, methodically building a narrative of Daniel Miller, the brilliant but greedy CEO who betrayed his partner and company for personal enrichment. He called Richard Thorne as his star witness. Thorne, impeccably dressed, spoke with practiced sincerity, recounting his discovery of the fraud and his agonizing realization that his longtime friend was the perpetrator. He looked directly at Daniel, feigning sadness. A performance I found sickening. When it was my turn for cross-examination, I started subtly. "Mr. Thorne," I began, "you were responsible for all financial aspects of Horizon Tech Solutions, correct?" He nodded. "Yes, that was my domain." I walked him through the company's financial controls, his sole access to certain accounts. Then I began to chip away. "You testified that Mr. Miller began acting erratically, leading you to investigate. What exactly did he do?" Thorne hesitated. He was distracted, short-tempered. I just had a feeling. I let his vagueness hang in the air. A feeling. Not any specific financial request or transaction he personally authorized. He insisted it was a feeling. The climax truly began when I called Dr. Arlene Kincaid to the stand. She was phenomenal, her testimony a masterclass in forensic accounting. With charts and diagrams projected onto large screens, she meticulously laid out the $8 million scheme, detailing the shell companies, the offshore accounts, and the precise flow of funds that never touched Daniel Miller's personal accounts. She concluded by stating, "Based on my extensive analysis, these funds were diverted by an individual with direct, ongoing access to Horizon Tech's primary financial systems and whose digital footprint aligned perfectly with the transactions in question." The courtroom was silent, save for the hum of the projector. Then came Mark Jensen, my digital forensics expert. He began by explaining metadata, IP addresses, and digital signatures in simple, accessible terms for the jury. He then displayed the recovered emails from Thorne's deprecated server. This email, Jensen stated, pointing to the Phase 3 mitigation and redirection message, clearly outlines a plan to frame Mr. Miller, including the creation of forged digital signatures and the manipulation of financial records. A gasp rippled through the gallery. Next, he presented the crucial metadata evidence showing that the supposed Daniel Miller authorizations originated from an IP address consistently used by Richard Thorne, and that Thorne himself had modified the spreadsheets after Daniel had last accessed them. Mr. Thorne planted these digital breadcrumbs, Jensen explained calmly, designed to point directly to Mr. Miller, while simultaneously covering his own tracks. I then played a recording from Thorne's computer, recovered by Jensen, an audio file of Thorne instructing an offshore contact on how to process transfers through a shell company. His voice, unmistakable, filled the courtroom. Richard Thorne, sitting at the defense table next to Eleanor Vance, went ashen. His face drained of all color, his eyes wide with a desperate, trapped look. Eleanor Vance, usually composed, looked absolutely defeated, her shoulders slumping. The judge's gaze hardened, her expression stern. Ada Martinez looked stunned, his carefully constructed case dissolving before his eyes. I remember looking at Daniel, who sat beside me, tears silently streaming down his face, not of sorrow, but of profound relief. I walked over to the jury box holding up the printout of Thorne's damning email. "Ladies and gentlemen," I said, my voice resonating through the hushed courtroom, "this is not merely circumstantial evidence. This is the truth. A truth meticulously hidden, but now undeniably exposed." The jury deliberated for less than 3 hours. When they returned, the tension was palpable. Judge Reed read the verdict, her voice clear and resonant. "On all counts, we find the defendant, Daniel Miller, not guilty." The courtroom erupted. Daniel collapsed into his chair, sobbing uncontrollably, his wife rushing to embrace him. I felt a wave of profound relief wash over me, the kind that only comes after fighting tooth and nail for someone's freedom. Richard Thorne, stunned, was immediately taken into custody. Based on the overwhelming evidence presented at trial, the district attorney's office wasted no time. Thorne was formally charged with aggravated perjury, felony theft, and obstruction of justice. The civil case for damages, which had been put on hold, immediately shifted its focus to Thorne. Horizon Tech Solutions, with Daniel back at the helm, quickly launched its own civil suit to recover the $38 million, which Kincaid and Jensen helped trace to various assets Thorne had secreted away. It would take time, but the path to recovery was now clear. Daniel's reputation was restored, albeit not without significant effort and public relations work. He walked out of that courthouse a free man, his name cleared, his future his own again. Here's what I learned from this case. Never underestimate the lengths to which desperation and greed can drive a person. Richard Thorne was not a common criminal. He was a sophisticated businessman who meticulously planned to destroy his partner to cover his own tracks. It reinforced my belief that justice often hides in the most unlikely places, buried beneath layers of deception, waiting for someone to dig deep enough. The broader legal lesson for viewers is critical. Your digital footprint is permanent, whether you think you've deleted it or not. Every email, every transaction, every login leaves a trace. For anyone facing a similar situation, where they are falsely accused of a crime involving financial or digital evidence, the warning signs are subtle. Sudden changes in a trusted colleague's behavior, unusual financial discrepancies, or attempts to limit your access to information. My practical advice is simple. If you suspect something is wrong, trust your gut. Document everything, even if it seems minor, and most importantly, if you are accused, retain an attorney immediately. Do not speak to law enforcement without counsel present, and do not try to fix the problem yourself. An experienced attorney can guide the investigation, bring in the right experts, and ensure your rights are protected. In a world increasingly dominated by digital transactions, understanding where your data lives and how it can be used, both for and against you, is paramount. Today, nearly a year later, Daniel Miller is thriving. Horizon Tech Solutions not only survived the scandal but emerged stronger, with Daniel implementing new, transparent financial oversight. He's back to being the visionary, developing groundbreaking software, and has rediscovered his passion for his work. He and Sarah have even had another child, a little boy named Arthur, which still gets me every time I hear it. Seeing Daniel's life restored, his family whole again, is why I do this job. It's not just about winning cases. It's about fighting for truth, for justice, and for the lives of people who often feel like the system is stacked against them. Every story like Daniel's reminds me of the profound responsibility I carry. Drop your questions about this case, or any other legal queries, in the comments below. I've got plenty more stories to tell, and I'll be back next week with another one.